afternoon, ladies and gentlemen, and welcome to the Public Service Commission meeting of February 4th, 2016. Chair Winslow is with us by telephone, I believe. Are you there?
That's correct. I'm here.
Okay, thank you. Before we get started on the minutes and the rest of the meeting, I do have some pleasant things to do, please. I have 2 awards. One to Heather Content for 5 years of service with the state of Delaware. You're welcome.
I can get a picture of that so you can put it on.
Thank you for your 5 years of service.
Thank you so much.
Hang on, just trying to figure out.
Oh, geez,
Okay.
figure it out.
It's an idiot-proof camera, but he's struggling with it.
It's one of those days. Okay.
Thank you.
And I have another one for Pam Knotts for 10 years of service with the state of Delaware.
This is my money.
That's your money.
One more for good measure. Great.
Thank you.
Thank you.
Thank you both very much. And now we have the minutes of the meeting of January the 19th, 2016. Are there any additions or corrections? If there are none, may I have a motion to accept them, please?
So moved.
I second.
Any questions on the motion? All those in favor, please signify by saying aye.
Aye.
All those opposed? Any, okay, abstentions? No. Okay, we're okay. There are no items on the consent agenda today, so we will go right to the regular agenda. The first item is legislative petition for review and recommendations on Delmarva Power and Light Company utility bill transparency. I believe we have Todd Goodman from DPNL.
Yes, you do. Good afternoon, Madam Acting Chair, Chair on the phone, and Commissioners. Todd Goodman for Delmarva. This is a compliance filing. I think it's the first time I've ever presented a compliance filing, but we filed in such a manner since there were so many people interested in this. We had quite a few interveners, so we thought we'd file, something that explained exactly what we were doing, instead of just sending in as a compliance filing. So I'm very happy that we are here before you. As you know, in Order 8835, it was determined by this commission that the amount that customers pay for compliance with Delaware's Renewable Portfolio Compliance Act should be broken into 2 in separate line items, one showing the more traditional forms of renewable energy, which here in Delaware, it's solar and wind. Those are our 2 sources. And one showing the qualified fuel cell. He gave us 2 options and on how to do it. And as we explained in the motion, option A, which would be showing it in 2 separate line items, is really the only practical way. Showing it in the notes section would, and to try to explain this in a way that someone like I can understand it, that the billing system is set up in fields, and the notes field is not designed intentionally to do calculations. So putting it up under option A, it is designed to do that, and we would just modify the manner in which it calculates and prints. A fraction of the time and cost associated with doing it the other way. You'd have to redesign the notes section, which I know this commission would not want us to take that time or cost, so we are not going to do that. And we appreciate having the 2 options, because that really was a nice way to do it for customers and for us. And then, of course, we also want to do what we can for customers to understand what the new charges are and to understand what they get for them. So you saw in the compliance filing, we showed the billing note that we were going to use as well, which I know wasn't part of your order, but we always try and cut down the amount of calls that we get, the kind of amount of calls that your staff gets, the DPA. So that note will be on there at least for several months and maybe longer. Plus, we'll do the education that we always try and do with our customers. Every customer will get a bill insert probably the month preceding that explains what the new bill is going to look like. And we'll do work on our websites. And we also, as you know, frequently get asked to come and explain things to sometimes church groups, civic groups. And so we'll be out there doing that as well. So if you have any questions, I'm here for that.
Do you have an idea of what date all of this will transpire?
Yes, it's going to, I should remember this because I did put the compliance filing together, but I believe it's May.
No specific date, May.
Yeah, well, it'll be bills beginning in May. So which I think May 2nd or something is a Monday, but yeah, it'll be with bills beginning in May. We always start with a full month's worth. So you'll be seeing, our customers will be seeing, I believe the bill insert probably the prior month. We leave it up to our communications folks. They have their work, their studies they do to see whether it's more effective to get it with this bill or prior. They've done it both ways, but they're working on that now.
Thank you. Any questions, Mr. Newman?
Oh, and I'm sorry, I should say then we're very fine with the order as drafted by staff.
Commissioner Drexler?
Yeah. My question is, I pulled out my bill, my actual bill, and I compared it with the exhibit, and you've added 2 lines. It was 9 lines under type of charge, and now it's 11 lines. And then you still have the 5 lines of the narrative underneath. Is that going to be, if you have enough room on the bill now, you're not going to go to 5 pages, are you?
No.
Okay.
No, no.
Okay.
The narrative down there, that's what we'll show. There's other information on there that was included in Phase 1 before you were lucky enough to be a commissioner. And DENREC was working on several of its own dockets at the time and asked us to include some of that information until they were concluded with their dockets, one of which they just concluded. So the timing was good, and we always, we do have a limited space on there, and as you know, customers, they get to about line 2 or 3, and then, they stop reading. So that's a great question, but yeah, it's actually adding nothing. The changes that in the space, it'll be almost the identical length of the note.
Right, for the note.
Yes.
But above that, you're going from 9 to 11. So that's, I don't know, you have a tiny bit of room on top and a tiny bit of room on the bottom. But just confirming that'll fit.
We ran it past our billing folks. They did some mock-ups. They said everything looks like it'll be great. I can get you a more specific answer if you'd like, but
No, I just want to confirm you're not going to go to a 5th page because that's a lot of paper.
Yeah, no, I hope not. I agree. It'd be a lot of paper.
Madam Chair, I'm sorry.
Yes?
Please.
Commissioner Gray, do you have a question?
Yeah, I have a
Okay.
question for clarification. So, if I understood you correctly, you're going to break out the qualified fuel cell line item on the front of the bill, but you've indicated also there's some text that will follow. I imagine this is the explanatory text that is displayed in the exhibit?
Exhibit B to the filing. If you don't have it in front of you, I can hand it to you.
No, I think I have it. But regarding that text, there's a line that states the qualified fuel cells provide customers with approximately 52% of that compliance.
Yes.
Question is that going to fluctuate period by period?
Annually.
You might want to put annual in that statement only because the other 2 exhibits that you pointed out here, that does fluctuate within those 2 around the 52%.
We change those numbers annually, Your Honor. So what happens is the compliance year is from May to June.
Okay.
And if the old, the language that was in there for the last year, or 2 years actually, we had what the RPS compliance was, which I believe last year was 13%.
Yeah.
And we would change that annually in June. So we will be changing this too. So at the end of next year, when the new compliance year starts, the RPS in general goes up. So that will bring down the percentage covered by the fuel cells.
Okay,
So it'll probably be 50% or 51% next year.
That's understood, but I think month by month, you're going to see the ratio of that
Absolutely.
fluctuate.
I see what you mean.
And so all I'm suggesting is so that someone doesn't then crowd your call center with, well, that's not 52% this month.
I
You might
understand
say
now.
annual or for the year.
That's a very good
Okay.
suggestion, and if the commission is okay with that, we will gladly do that because that's a good point.
Yeah.
As long as you stay on
Then I have one last question. Are there any material costs, consequences associated from changing the bill that are going to be reflected in, say, another rate request?
We don't believe so.
Okay.
One of the reasons, as I explained, that we chose option A is that the bill is actually calculated in that manner every month because the commission sets the wind and solar portion. That's an annual monthly rate. That 0.03939 per kilowatt hour is reset once a year by the commission, where the qualified fuel cells is monthly, depending on what's generated, the cost of gas, what they get for the PJM sales. So we have to calculate that way anyway. So all they need to program in is the printing function.
Print out, yes.
Yeah. So it should not be much at all.
Very good. Thank you very much, and thanks very much for
Thank you.
Yeah.
presenting this and for responding quickly.
Thank you.
Mr. Geddes.
I'm acting chair and members of the commission. Just following up on the colloquy between Commissioner Drexler and Mr. Goodman. Fonts are wonderful things, and I'm sure at a 8-point font, they could probably get 4 or 5 more lines on the bill. But I digress. This is basically an order that follows up your prior order in this matter, 8835, mentioned by Mr. Goodman, where you directed the company to consider 2 options, and they went back, studied it, and for the reasons Mr. Goodman suggested to you, they have decided option A is the preferred way to go, since it is less time-consuming in billing and basically programming. And this order would direct the company to pursue and follow up with option A, and to begin this in May, and also educate the customers as to specifically what this is, as Mr. Goodman has indicated. So I do think it is consistent with your prior order and the compliance filing that has been made, and staff would recommend it for your approval.
Questions, Mr. Geddes? Public Advocate.
Thank you, Madam Acting Chair. I have nothing to add.
Oh, thank you. Deborah Scott from Denrec is... Okay. Mr. John Nichols, do you have anything you'd like to add? And I don't see Representative Kowalko in the room. Is there anyone else from the legislature hiding back there? Mr. Stevenson, I did see you. Would you like to add anything?
No, I think it went fine.
All right. Thank you very much. All right, Commissioners, you have before you order number 8819. What's your pleasure, please?
Madam Chair, I recommend the Commission adopt order number 8819 as submitted.
I second.
All those in favor, please signify by saying aye.
Aye.
Aye. Any opposed? Any abstentions? Motion carries. Thank you all. Thank you, Mr. Goodman.
Thank you.
The second item on the agenda is the matter of the application of Delmarva Power and Light, Exelon, Pepco, Purple Acquisition Corporation, Exelon Energy Delivery, and new special purpose entity for approvals under the provisions of 26 Delaware Code, subsection 215 and 1016. I believe, Ms. Mayrack, you're going to be the lead on this one.
Thank you, Madam Acting Chair and Commissioners. In my role as counsel to the Commission on this matter, as you know, this is the docket that's been ongoing since June of 2014 concerning the acquisition of Pepco Holdings by Exelon. And although this Commission has already approved the acquisition and the settlement agreement, as you know, because of the District of Columbia Public Service Commission at first rejecting and then continuing to consider this transaction, this docket has continued for your consideration. In this case, one of the interveners in this docket, Jeremy Firestone, has filed various motions beginning on December 11th, 2015, with a motion to cease and desist concerning conduct of the Delaware Public Advocate. This was filed before the hearing examiner. The hearing examiner granted an order on January 7th, which would have stayed consideration of the motion. Mr. Firestone then filed an interlocutory appeal with this commission on January 12th, a petition for interlocutory review that would ask the commission to consider the hearing examiner's decision immediately before the docket would continue to proceed. Commission rules require that if the commission does not take action on a petition for interlocutory review within 30 days, it is deemed to be automatically denied. Mr. Firestone could not attend today's meeting. The next meeting is on the 23rd, which is obviously outside of that 30-day time period. So it would be an appropriate action for the commission to simply delay consideration of the petition until the 23rd. This would prevent the automatic denial of the petition due to the 30-day period elapsing, and then allow Mr. Firestone to present his petition before the petition at the next meeting. I would also note that the other parties in this docket also have the opportunity under the commission's rules to file an answer to an interlocutory petition. To date, they have not, and it may be appropriate for the commission to also set a deadline for the filing of any answers before the next meeting so that there's sufficient time to review. Under the rules, parties would typically have 3 days to file an answer. If the decision is made today, on Thursday, the next 3 days would be Friday, Monday, Tuesday. So perhaps by 11:59 on Tuesday would be an appropriate deadline for any answers to be filed. Although I think the other parties would also might have a view on that deadline as well.
Thank you very much. Mr. McGonigal, do you have anything you'd like to add?
Just, Your Honor, that, please, Madam Acting Chair, I think that timeline sounds fine. We were under the understanding that this would likely get pushed to the next meeting. That's why we didn't file, but we will file, so that deadline works for us.
Okay, thank you very much. Mr. Geddes?
Could I have a moment, please?
Sure.
Perhaps I should go first,
Yeah,
Madam
perhaps.
Acting Chair.
Okay.
Well, the decision, the motion is directed towards us anyway. The public advocate's not intend to file a response to Mr. Firestone's application for an interlocutory appeal. As far as we're concerned, he can have it. But we do intend to file a response to Mr. Firestone's cease and desist motion. And with respect to whatever deadline the commission sets for that, the public advocate will read it.
Thank you very much.
Madam Acting Chair, I guess staff is the odd person out. Yes, 3 days is the normal time for response. Obviously, the commission rules and upon application, oral or written, I think the commission can set the time at whatever it believes is the appropriate time in order for you to have sufficient consideration. Think about Ms. Iore's comment with regard to the appeal itself and her position, because it is really directed at the DPA, and staff's position is more, will be more along the lines of commission authority, et cetera, with regard to the relief that Dr. Firestone's asking for. So with those comments, whatever the commission feels is the appropriate time to have comments or responsive comments is fine with us.
Any comment from Denrick? Commissioners?
Madam Acting Chair, Delaware Power is also a party to this docket. Oh, I'm sorry. Okay.
He's the intervener.
All right, commissioners?
They're like the chicken and practice, but not commission.
Madam Chair, I could use a little bit of clarification, probably coming from the legal side and the procedures of the commission. So I see two things on the table. There are first the appeals, which I think I heard the public advocate express a position regarding those and their response there too. But then there is a request, as I understand it, for delay until the next commission hearing. And what I'm curious to know is, do any of the other parties have a say in whether or not to delay? What is the legal position on that question, please?
If I may speak to that, I think it's more a question of comedy. The matter was put on the commission's agenda without consideration of the individual who was presenting the motion. And as a result of his prior plans not to be here, I think it is appropriate for the commission to table it or otherwise defer it until the person who made the motion for the appeal is able to be here. So I think it is appropriate, and certainly the commission can defer this matter should they choose to do so. And I would suggest to you, I think the circumstances are appropriate that it be deferred.
Is that the opinion that carries through all of the other parties who are affected by that delay?
Ms. Ivory has no comment.
She wants it right now.
I guess what I'm looking for here is
The public advocate would have liked very much for it to have been heard today. However, the public advocate would also like to have, for the commission's consideration, its response to Mr. Firestone's cease and desist motion. And given that, I think at least the public advocate was under the impression that because of Mr. Firestone's unavailability, the matter would be moved, and that the commission would set a deadline for those responses. Despite our preference that it had gone forward today, I think given, as Mr. Geddes has explained, that Mr. Firestone is not available, that the public advocate reluctantly acquiesces in moving it to the next meeting if the commission so desires.
okay, that provides me some comfort and safe harbor in front and in view of the decision we're about to make. Thanks.
And Commissioner, just to clarify, if staff did not really have the option to schedule around Mr. Firestone's availability, because if it had not come up within 30 days of January 12th, because we are required to give 7 days notice of our agenda, we could not include it on the 19th because it was filed late on the 12th. So we missed the 7-day window to provide notice for the 19th. That puts us, the next commission meeting is today, the 4th. If we waited until the 23rd, by operation of law, Mr. Firestone would have lost his petition. So that I think it is an accommodation, but it gives Mr. Firestone his due process limited inconvenience to the other parties, hopefully.
All right, and one last question. Clarify for me again, if and when the commission requests responses, by statute, we have a duration of 3 days? Is that what you're...
The regulation directs a 3-day period for parties to file an answer to the petition for interlocutory review. It would certainly be the commission's prerogative to enlarge that deadline under these circumstances.
I have a question. Can both of those objectives be met in one motion, or will we need two separate? One to defer and one to set the filing deadline?
Either way, I think.
Okay.
Just point of clarification, maybe context, if I might. Interlocutory appeals usually are taken from an ongoing case where the hearing examiner is involved and there are things going on, and a party brings it to the commission because they want the review as quickly as possible because it might define the way the case may proceed. And that's why the timelines are very short. In this case, that's not where we are. As your counsel indicated, the DC matter is still ongoing. This matter is not as time sensitive as it might be, since there's nothing going on in the docket at the moment as we await the results of the DC matter. So it it's a little different than the normal interlocutory appeal where time is of the essence and people are trying to get a final decision from the commission so that they can proceed in the underlying docket. So I would just point that out as a contextual comment.
Thank you. Commissioners, your pleasure.
Madam Chair, I'll move that the commission accept a delay on this particular matter until our commission meeting on February 23rd, 2016.
Okay.
So there'll be two separate motions?
And furthermore, that the commission accept the responses according to the statute as indicated, 3 business days.
Okay, and that would end on the 11:59 on Tuesday, the 9th of February?
Yes.
And then if I could just clarify, since there are a lot of matters going on in this docket, what the motion would be to delay the commission's consideration of Mr. Firestone's petition for interlocutory review until
February 23rd.
I'm sorry,
Until February 23rd.
until February 23rd.
Yeah.
And that the parties' answers to that petition for interlocutory review would be due by the end of the day on Tuesday, February 9th.
I can accept that as a friendly amendment to the language.
And I second.
Any questions on the
This is
motion?
just to clarify,
Oh,
we're not considering the motion, because that is before the hearing examiner. We're simply considering the petition for interlocutory review.
Can we go off the
All right,
record?
point of clarification, please. All right. Let's hear the concern.
Here's the concern. As well, it's whether they. I think there's going to be a general discussion. Let's just stay on the record.
All right.
As Ms. Ira indicated, she takes no position with regard to whether the appeal comes before you on an interlocutory basis or at some other time down the road. But it's the substance that she is most concerned about. Now, if in essence, if you're going to hear this on the 23rd, you're in essence, I mean, the interlocutory nature of it's almost moot because you should hear the substance of the appeal, which is the cease and desist order. What Mr. Firestone has complained about is the hearing examiner's decision on his petition. And he originally brought the cease and desist with regard to the hearing examiner's order. He then filed for interlocutory relief. So the point of clarification I'm trying to make is that both matters should be heard at the same time, and the response can be either in 3 days or whatever, but they should be heard together. Because
Well, no, but he also filed a motion to quash, vacate, and set aside the hearing examiner's stay order. So he's got 3 things pending.
Right, and
Petition.
I disagree. What is before this commission is a petition for interlocutory review. This commission might decide to remand this to the hearing examiner. This commission might decide not to actually reach the substance of that petition.
The hearing examiner already decided it.
he decided,
That's what
and
the
he's
order
removed
is.
himself from the consideration, any further consideration of it. And there's a question in the first instance whether a hearing examiner should have even issued an order since he didn't have authority to, because his authority under the original scheduling order had ceased to exist. And he took it up sua sponte without any direction from the commission as to whether he should have considered it in the first instance. So it is a little complicated.
Let me try something here. As I read the substance and the content of the information presented for me to prepare for this hearing, there are multifacets to this, and the intent of my motion was to defer all of the scope of this matter to February the 23rd. So I'm not, perhaps I'm missing something in terms of parsing this into an interlocutory versus a cease and desist versus a stay, but...
And that was my attempt to get clarification. I believe that was Ms. Iori's concern as well. I would suggest, following up on your concern, Commissioner Gray, is that whether it's 2 parts or 3 parts, that whatever Mr. Firestone has filed be considered at one time in front of the commission.
Yeah, that is clearly the intent of the motion that I have submitted or proposed. Madam Chair?
That's what I understood.
In that case, then my clarification would be inappropriate, and I would withdraw that. Because my advice to you as my client would be to cabin these matters. This commission still has the authority, just because a hearing examiner whose power is delegated by this commission has decided not to hear a particular issue, doesn't mean that this commission can't remand it and direct that hearing examiner to do so anyway. So there's an option, I guess, as the parties are suggesting, to consider this all at once. That's one way to go. I'm suggesting that there's a way to cabin and consider these one at a time. Ultimately, it's the commission's decision as to how to proceed.
I guess my concern in that regard would be that in order to contemplate informed decision-making for categorizing these matters or parsing them, in my view, means that we must delve into them today in terms of putting some aside or leaving some on the table. And I'm not sure that that really is the intent without one of the key parties at the table today. So that's why I'm suggesting we defer the entire matter until the 23rd February.
Right?
Madam Chair, I think, well, I'm sorry. Point of order, Madam Chair. I think we have a motion on the table, and it's been seconded. But there is, I think, one of the parties who has come forward.
Tom McGonigal for the joint applicants. I just wanted to be sure we knew what we were filing in terms of, whether it was just the interlocutory or the latter. We'll do whatever the commission says. I just wanted to make sure we know what we're supposed to be responding to. So.
And your motion, as you explained, entails the entire matter.
The entire matter, yeah. So I look at the full scope of what's been presented to me in preparation for this hearing, and I'm thinking that I simply close that today and open it up on the 23rd February.
Right, the whole thing.
And it's seconded?
And I second, yeah. Mm-hmm.
Are there any questions on the motion? All those in favor, please signify by saying aye.
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 Aye. Any opposed? Any abstentions? Motion carries.
Madam Acting Chair, one point of clarification. I'm sorry, but under the Commission's regulations, the responses to the interlocutory appeal motion are due within the 3 days. However, we do have the two other motions, one of which is the motion to quash, and one of which is the motion for a cease and desist order. Are you expecting the responses to those motions to also be due on the same day, or would the parties be given additional time to respond to those motions if they are going to respond to them?
My intent with the order was to acquire the responses that are established by statute within that time frame of 3 days. And if there are others that are not within the scope of that 3-day requirement by statute, then I had not intended that you present those as well at that time.
In that case, then I think we would need a motion with another date for the deadline for those motions for which there is no regulation or statute governing the response deadline.
And so are you talking about the two that are the motion to quash, et cetera, and the motion for a cease and desist?
Correct.
Specifically those?
Yes, specifically those two.
Let me ask this question. Coming into today's hearing, did we already have those responses from the other parties?
No.
Okay. And so is there, for that very same reason, a need to establish another date going into the deferred date?
Yes.
Okay.
If you are going to hear all of the motions on the 23rd, then yes, there would be a need to establish another deadline.
Okay. I'm going to ask staff or one of the legal advisors for the commission what would be a reasonable time to receive those, administer them, and distribute for the commissioner's review.
I would suggest that it be 2 days after, say, Thursday. I mean, the commission has the extra week, and it's really up to you when you want that material. But in terms of preparing it for staff, we'd like an extra couple of days beyond the response to the interlocutory appeal.
So you're looking at the 11th of February.
11th or the 12th.
I can make
That's it. What's the
That's 11.
11th? So
Motion?
I make a motion to.
I'm sorry, just,
Okay.
will then Mr. Firestone be allowed another opportunity to respond to the responses? Here, to speak for himself?
Why?
Typically, parties get,
The rules
they,
don't,
they file, well, we're
The rules
outside the
don't
rule
permit it.
now.
the rules don't provide for responses or answers to. They provide for motions and answers. They don't provide for a response.
Well,
But hearing examiners often indulge parties to respond to the answer.
it's fair. May I comment? I think Councilor raises a good question, and she's also raised a question that I hadn't thought about in her prior comment, was whether you want to send all this back to the hearing examiner. Because he was in it, then he withdrew, and of course you can say, well, you're back in it again, and here are the issues. So it's really up to you as whether you want to hear this directly or not hear it directly. But with regard to the second point, sorry, I lost my train of thought. What was it? I was trying to come back to your comment.
Mr. Firestone having the opportunity to
Yeah,
respond
I
to
think
your filings.
there are two ways that you could do this. One is notify him of the fact that responses are going to be made on Tuesday and Thursday of next week. And knowing Mr. Firestone, if somebody responds to his motion, he will attempt to respond. And at that point, you should indicate, I think, whether you are looking for additional responses or not. And that's up to you as to whether you think, in your informed judgment, that having responsive pleadings, since Ms. Iowa is correct, the rules don't contemplate it, but that doesn't mean that you can't allow it. And if you think that that would create a better record for your decision or whomever is going to decide this, then you can certainly suggest that, or wait to see what happens, and if he files something, decide at the 23rd whether you'll consider it or not.
Where are we with the motion?
Okay. Well, I have a question.
Go ahead.
For Mr. Gaddis. I have a question about what you said about remanding to the hearing examiner. Is there precedent for that, where the commission has gone back and said to the hearing examiner, after the hearing examiner has determined that he wouldn't issue an answer or an order, that the commission has gone back to the hearing examiner and said, you will hear this, we're remanding it back to you?
The short answer to your question is I'm aware of none.
Mm-hmm.
But again, it depends on how you analyze these various motions. But to the extent that you have a order from the hearing examiner that stays Mr. Firestone or Dr. Firestone's request, then that clearly comes up to you and you decide whether that's appropriate or not.
Mm-hmm.
But he's also asking you on the merits with regard to future actions taken by the DPA and whether you consider that a separate action or not. The hearing examiner has suggested that his motion as it's directed to that activity be stayed. And I don't think there would be anything to send back to the hearing examiner.
Okay.
Yeah, just as a comment, I'd worry a little bit about remanding this to the hearing examiner because it seems the hearing examiner is part of the substance of some of the motions that are on the table that need contemplation by the commission. So I would be much more comfortable bringing the matter and the evidence in the hearing to the February 23rd venue. And I tend to agree that from brief experience and history with Dr. Firestone, if he has some feedback related to the responses, he's likely to present them prior to our commission hearing. I'm not sure where we are, Madam
I
Chair.
was going to say, if I remember correctly, we have a motion that has been seconded, And I'm ready to call for the vote on that motion.
I don't remember.
correct?
I don't remember the motion, though.
But
Sorry.
do we have a new motion that we're creating a deadline to respond to
Oh,
motion one
okay.
to quash vacate and motion two, I'm calling them motion one and two, Dr. Firestone's motion for a cease and desist order.
I thought
Are
you
we
made
now
that motion.
separately? No, I haven't
Yeah,
yet.
okay.
Okay, so we talked about the 11th, so motion to create a deadline to respond to the two motions, motion to quash, vacate, and set aside unlawful hearing examiner stay order, and secondly, Dr. Firestone's motion for a cease and desist order to be 11:59 on February 11th.
I second.
Any questions on that motion? All those in favor, please signify by saying aye.
Aye.
Any opposed? Any abstention? Motion carries. Thank you all very much. On to item 3.
Commissioners, then the consideration of whether Mr. Firestone files a response, was there an intention to set a deadline for that as well? Perhaps of the 16th, which would be a week before the meeting?
Well, did the public advocate actually, did Ms. Iori mention that there is no,
There's no requirement,
Required-
but
oh, it's not a
there is
requirement.
leeway to allow that response, and the commission could certainly set a deadline for that response.
Well, what I think I heard from one of the legal advisors at the table is that there's no rule to govern that. The second thing would drive me to ask the question, what is Dr. Firestone's availability to meet a deadline we might put on the table for him? And if there's no rule, I'd be much more comfortable if he's not here, not doing so.
So-
Then there would be no response, written response permitted.
not, well, we're
So,
not saying
well-
not permitting one, we're not deadlining it. I mean,
Are you saying that if we don't deadline it, we cannot permit it?
Well, I think it's not, I think if you have deadline, it's unfair to the other parties that won't have an opportunity to prepare
okay.
their oral arguments to, or tailor their oral arguments to that. It seems to me that Dr. Firestone is going to be bound, just as we are, by whatever deadline you give him. Just as we are bound by the deadline that you've given us.
Okay, so before we go to the third motion, let me ask, is there another link to the chain that we can discuss before we enter another motion proposal?
I don't believe so.
Any other party
Yes, I would.
contemplate one?
Yes, I would.
Thank you.
As I said before, it's your docket. You need to consider what you think would be most appropriate and most informative for you to decide these motions. If you think having a responsive pleading by Dr. Firestone would be helpful to you in deciding these issues, then you should request that he file his responsive pleading at the time, the information, on the Thursday before the meeting or whatever time you think is appropriate. But that's your decision. You need to decide that. As we've said, there's no rule on it, so it's really up to you.
Right.
Okay,
Matt?
so thank you. It has to be before the Thursday, because the Thursday is when all the information goes out.
Yes.
So it
It
has to be by the
prior to the 16th.
So there are deadlines on the 9th, which is 3 days from today.
11th.
Yeah.
On the 11th, which is 2 days later. 3 days after the 11th would be the 16th, which would be a week
Yeah.
before the
That would be
meeting.
Tuesday.
Yeah, that would be.
Again, going back to, we don't have a rule addressing this specifically, but in the context of interlocutory appeals, parties typically get 3 days to answer. Again, given, as Mr. Geddes has pointed out, the generally expedited nature of these appeals. So 3 days would likely be a reasonable deadline.
This one mine.
And
Okay.
then it gives a week to all the parties to consider all the filings for the 23rd meeting.
All right, Madam Chair, I'd like to offer the motion that the commission has established February 16th as the deadline, 11:59, February 16th as the deadline for Dr. Firestone to respond with respect to this docket.
I second.
Any questions on the motion? All those in favor, please signify by saying aye.
Aye.
Any opposed? Any abstentions? Motion carries. Are we finished? All right, thank you all. On to the third matter on the regular agenda, the matter of the notice of potential violation of 26 Delaware Administrative Code, subsection 8001, and associated civil penalties assessed to Delmarva Power and Light Company. And I believe this is Ms. Brenda Mayer.
Madam Acting Chair, Commissioners. This is docket 15-1425, which concerns notice of potential violation of 26 Delaware Admin Code 8001 and associated civil penalties assessed to Delmarva Power and Light Company. You have before you order number 8799, which asks the Commission to approve a consent agreement between Delmarva and staff, as well as to assess civil penalties upon Delmarva in the amount of $5,500. This stems from an event that occurred on Wilmington side on August 14th, 2015, in which a contractor working for Delmarva, Brandywine Construction Company, struck a buried sensing line for a regulator in Delmarva's natural gas pipeline system. And a sensing line is a smaller auxiliary line that runs parallel to the main that helps the system regulate the volume of natural gas that's flowing at any given time. I hope my layperson's explanation is sufficient. And Jerry Platt is certainly here to expand on that. Striking and breaking this line with the excavation caused an immediate high-pressure event with the regulator not receiving any input of gas. And then what that high-pressure surge throughout the system then caused other regulators throughout the city to actually shut down the system. This resulted in low pressure throughout the city, which caused pilot lights to go out and for some customers to experience the natural gas odor. Even though the incident was the event was on the east side, there were citywide issues, over 200 customer calls. And the reason that the line was struck by the contractor was due to a failure to mark the sensing line before the excavation took place. Again, because this was a smaller auxiliary sensing line and not the main. Staff began an investigation on the 17th of August. On September 25th, a notice of potential violation was issued, and last month, on January 20th, staff and Delmarva reached a consent agreement in which Delmarva took appropriate steps to resolve the event, made changes to their procedural manual concerning this type of event to prevent future events. And Delmarva also waived the right to an evidentiary hearing in this matter. Also agreeing to the imposition of civil penalties. One was for the failure to mark the line. This is 49 CFR section 192.614C5. That would be a $5,000 civil penalty. The second penalty is $500. This is for a failure to follow the procedural manual, which would require the marking of the lines. And that's 49 CFR 192.605A. Again, staff and Delmarva have reached a consent agreement resolving this matter, and that would also impose the fines for the civil penalties in the amount of $5,500. And staff urges the Commission to adopt order number 8799.
Thank you. Any questions?
I have a question of Delmarva, and that is, how are these sensing lines marked?
I have Bob Kitson, who is the manager of gas engineering, with me, and he can probably provide some additional explanation in that regard.
And I can expand on my question first, and that is, the contractor hit the sensing line. Had the contractor notified Delmarva that he or she would be excavating there, and would it have been marked at that time? Are they always marked kind of a compound question. And how marked? Like, how are they marked is the question, I guess.
Just maybe I can preliminarily respond to your question. Pam Scott here on behalf of Delmarva Power. When work is going to be done in a particular area, normally Miss Utility is contacted and lines are marked out in the field. In this particular case, there were a number of things marked, but the sensing lines for the regulator station were not marked. And Mr. Kitson can probably go into some more detail about that particular aspect of this, but yes, generally speaking, you will mark everything that's going to be in the field where excavation is going to occur. Traditionally, sensing lines were the type of, in terms of where they're located, and some of them have been in the ground for a very long period of time. Sometimes our records were not as accurate about that particular information. And I will ask Mr. Kitson with respect to this particular station.
And Mr. Kitson, the contractor did contact Miss Utility before this began?
Yes.
Is that correct? Okay, because I couldn't find that. And so at that time, whatever needed to be marked with the orange spray pen or whatever was marked, and this was not. Is that?
That's correct.
Okay.
Do you need any further explanation beyond that, or is that pretty much answer your question?
No, I really wanted to know if all those steps have been followed prior to the, just
Yes.
didn't
they-
get marked. Okay,
that's
that
correct.
makes sense.
That is what happened.
Okay.
And just one clarification to the summary that was provided with respect to the violations by Ms. Mayrack. Delmarva was charged with 2 specific violations, but in terms of the consent agreement, the parties agreed that 1 violation was in fact, we were admitting to for a total penalty of $5,500. So we admitted to a violation of 49 CFR section 192-614C5, but not with respect to the other, and that was the negotiated settlement of the parties.
What is that section titled? Sorry. What is that for in principle?
That's the damage
Yeah, that's the-
prevention program, which must be in place and must also be carried out, which basically means there must be a policy to mark the lines, but then the lines must actually be marked.
Yeah, that's titled Damage Prevention Program.
So I have a couple of questions, Commissioner. Is it Chair? Okay. So I know that this has to do with a penalty for this matter, but I'm not sure a penalty is really going to always incentivize the safe treatment and or administration of this type of fuel distribution. So I think I heard that Delmarva is being fined for failure to follow the procedural manual, but the remedy, it seems, you made some changes to the procedural manual. So does that imply the procedural manual was correct? If so, why then will changes fix the problem?
We have made some modifications to clarify our procedural manual, specifically with respect to sensing lines, to make it very clear that is indeed an item that needs to be marked in the field, along with the other gas distribution facilities. In addition to that, we have also provided very specific training to our personnel as a result of this incident, so that they are thoroughly aware of how regulator stations operate, the various components of that, and what needs to be done in terms of marking and locating those particular lines in the ground.
Okay. In a word or two, what would you characterize this as being root caused by? Training? Negligence, oversight, sloppy work? I mean, those are the real crux of what needs to be solved in most of these matters, as opposed to a penalty.
Right, and that's one of the other aspects of all of this, of course, was when we sat down and met with Mr. Platt and his counsel. We talked about the standards currently in effect, what would need to be revised in our internal working standards to better address this issue. So we did discuss that aspect, and I believe Mr. Platt has a copy of those revised standards. We also talked about the need to better educate our field personnel about regulator stations, about sensing lines, about that process, and also to make sure that our documentation with respect to the location of these sensing lines is accurate and is up to date and can in fact be located in the field.
Okay. Well, thank you. I appreciate that because, an ounce of prevention in this arena can generate a tremendous.
Totally agree with you, Commissioner
Yeah.
Gray.
Okay. Thank you very much.
Commissioner Drexler, do you have any questions?
I do not.
I have just one of Mr. Platt. Are you comfortable, Mr. Platt, that with these changes that things will work much better? I know you have a lot on your shoulders as far as all of these gas lines and all, and potential for the loss of life. And I just want to be sure that you are comfortable with the changes that occurred in the.
Yes, I've read their revised policy, and they've definitely, it's very extensive. It goes into great detail in giving direction to staff as to how to carry out that duty. The policy itself, I think, goes about as far as you can go to describe what duties have to be.
Thank you. All right, and now we're going to need a motion to adopt order number 8799, I believe.
Madam Chair, I move that the Commission adopt order number 8799 as submitted.
A second.
Any questions on the motion? All those in favor, please signify by saying aye. Aye. Any opposed? Any abstentions? Motion carries. Thank you all very, very much.
Thank you.
All right, now, we have, in the matter of the formal complaint of Emblem Associates against Artesian Water regarding a contribution in aid of construction dispute. If you remember, we discussed this at our last meeting. And who do we have? Mr. McGonigal on this one.
Yes. Thank you, Acting Chair, members of the Commission. Tom McGonigal representing Emblem Associates in this matter. This case involves a dispute between my client, Emblem Associates, which is building a residential neighborhood up in the Christiana Mall area, and Artesian, which is a designated provider of water service for that area. The case involves a contribution in aid of construction, commonly referred to as a kayak, which is being assessed against my clients with respect to certain improvements. More specifically, the case involves a dispute over the efficacy of the kayak being assessed, which my client contends is not a proper assessment, and Artesian disagreeing with that contention. There's an important timing issue here in that my client plans to finish construction in time to open in May and does not, and Artesian does not want to provide water service until the assessment or the kayak is paid. So my client, very much wants its sort of day in court on the substantive issues, but holding up progress on the development is very costly. So the reason for the motion was to ask the Commission to sort of effectuate a process by which Artesian's client's interests could be protected while allowing the case to move forward and provide water service and let the issues be resolved. Since the motion has been filed, Artesian and Emblem, through Jack Strepler and I, have reached a resolution to the motion. Essentially, our clients are entering a water service agreement that specifically requires my client to pay the kayak, but provides that if the Commission is to conclude that the kayak was improperly assessed in whole or in part, that my client would be entitled to a refund within 30 days of that decision. So on behalf of my client, we think this is a reasonable resolution to the motion. It allows the substantive case to be resolved in sort of a normal course. In fact, the hearing examiner has been assigned and schedules are being circulated for that purpose. And so that we would ask that the Commission approve the resolution of this motion in the form of the stipulation that we submitted.
Thank you. Mr. Shrepley, do you have anything to add?
Good afternoon, Madam Acting Chair, Commissioners, staff, and the advocate. Artesian agrees with Mr. McGonigal's recitation of where we are in the proceeding. Artesian filed our answer to the complaint last Friday. So we disagree with the complaint on the merits, but we are in agreement with the proposed stipulation. I have signed it so that Emblem Associates can proceed with their development, and then the hearing examiner and ultimately you commissioners will make a decision on the merits in the fullness of time.
Thank you. Ms. Mayrack?
Madam Acting Chair and Commissioners, staff does not oppose the stipulation and proposed consent order that's before the Commission today that the parties have presented, and we look forward to participating in the process on a less expedited timeframe for the hearing examiner.
Thank you very much. Public Advocate?
Thank you, Madam Acting Chair. The public advocate is not participating in this docket.
Okay. Commissioners, do you have any questions?
I do. This question is for Mr. McGonigal. Is the construction of this project still on pace to be finished in May?
It is, but it's at that critical juncture where they have to get water to the property, I think by somewhere in March. Otherwise, we'll get off schedule.
So March is when you need the water.
Yes, to be open by May.
And there was a lot of information here about escrow and then no escrow. So when you say the potential refund, Mr. Schreppler, do you mean that it will be held in escrow ultimately?
No, Artesian is going to cash the check, and just like with temporary rate increases subject to refund, we have the resources to pay the refund in whole or in part if the commissioners agree with the allegations in the complaint. I might add, when this dispute began between Artesian and Emblem, Emblem was represented by an out-of-state law firm, and their proposal was that the monies be paid into escrow with a lawyer in Harrisburg who represents Emblem and is not a member of the Delaware Bar. Artesian did not jump at that chance. To their credit, Emblem found their way to Mr. McGonigal, experienced here and a member of the Delaware Bar. So we think Artesian, our position was that Artesian is subject to the orders of this commission. And the commission, we would not have to go beyond this commission for a refund to be ordered. If it was with an independent escrow agent, whether that be in Pennsylvania or Delaware, those independent escrow agents are not subject to the jurisdiction of this commission. So we actually got the check today. It should clear by tomorrow, and we will be providing water. If you order us to refund in whole or in part, you know we're going to do what you order us to do.
Thank you.
And we're comfortable with that arrangement.
Thank you.
All right. Any further questions? Okay, what's your pleasure?
I have a question. What action are you looking for from the commission today?
Order.
Essentially to approve our resolution of this motion in the form of the stipulation filed.
And staff and our legal advisors have agreed to the stipulation.
Staff's view would be that there's no requirement that the commission approve the stipulation and consent order. That staff had proposed to the parties that they had the option simply to withdraw the expedited motion for relief. However, I believe the parties came to the commission today because they desired the approval of the commission of the stipulation and proposed consent order, which the commission, staff does not oppose the commission giving that approval.
Commissioner Gray, I could add something I think that would clarify things. Mr. McGonigal inherited a position taken by the lawyer in Harrisburg that if they wanted the escrow because there is language in the regulation that says that a contribution in aid of construction is not refundable. What that language was intended to mean is before Regulation Docket 15 was amended in 2006, water companies had the option of collecting funds from developers either as an advance, which is essentially a loan that gets paid back over the years, or a contribution in aid of construction that does not get paid back. Well, it's better for ratepayers for a contribution because when the loan is paid back over time, those payments from Artesian to the developer are added to rate base. The contribution is a contribution for all time. And the lawyer in Harrisburg said, well, if we pay you this money, Artesian, the commission can't order you to refund it. Artesian took the position that that was nonsense. You always have the authority, if you determine that we're doing something illegally, to tell us to stop it and to reverse it. So Mr. McGonigal was able to persuade his clients that you commissioners have the ultimate authority to determine whether this contribution is correctly demanded and calculated by Artesian. That's how we got here. And I think Mr. McGonigal's client would just like the comfort of hearing that you all agree that you have the authority to order Artesian to refund if we've done something improper.
Ms. Minnick?
Again, I'm representing staff right now. Unfortunately, the commission is without its own counsel on this matter, although perhaps Mr. Geddes would have something to contribute. But staff's view is that the commission's approval is unnecessary, but it is not harmful. I mean, the commission, if it is the commission's prerogative, can certainly approve the stipulation and proposed consent order that the parties have put before you today and are asking for approval. So it is.
I would feel more comfortable if we approved the stipulation and proposed consent order, but the other two commissioners?
Well, what do we do with the motion for expedited relief?
The stipulation and proposed consent order basically moot the motion for expedited relief.
Okay.
And that's because there was an agreement.
Correct.
Okay. And are we also making any decisions regarding a future refund order or potential? Are we just acknowledging that there is a potential for?
Not at this time. A hearing examiner has been appointed in this matter, and the substantive dispute about the kayak and the amount of the kayak will proceed before the hearing examiner, who will hopefully bring findings before this commission to consider. This is simply about the agreement of the parties over the initial payment of the kayak and then a withdrawal or a mooting of the motion for expedited relief. So that there's a water services agreement in place and the project can move forward while the substantive dispute is heard before the hearing examiner. There's no decision on the merits of that substantive dispute.
Okay. Madam Chair, I can move that the commission adopt and agree to the stipulation and proposed consent order resolving complainant Emblem Associates LLC's motion for expedited relief.
And I second.
Thank you very much. Any questions on the motion? All those in favor, please signify by saying aye.
Aye.
Any opposed? Any abstention? Motion carries. Thank you all very much.
Thank you.
And now, the last item on the agenda. The matter of the provision of standard office supplies to members in the service territory of Delmarva Power and Light Company. This is the second tranche. Ms. Pam Knotts and Jim Letzelter.
Good afternoon, Madam Acting Chair and Commissioners. I have with me Jim Ledzeller from Liberty Consulting Group, and he's here to present the results from the Delmarva Standard Offer Service Tranche 2 that was held this past Monday. As you'll recall, these are the contracts that will begin on June 1st of 2016. He'll first present the public version of the results from the tranche, and then if the commissioners so will, we can go into an executive session to discuss the actual details from the auctions. So Jim is here to start with the public version.
Thank you. Good afternoon, Commissioners.
Afternoon.
We will jump right into a summary of this. Go ahead. Page forward, please. We'll start with a summary of this Monday's auction. The auction was for just 3 blocks, totaling approximately 150 megawatts. In short, we found that the Tranche 2 auctions were consistent with the RFP. They did result in prices that are consistent with market conditions, and that the auctions were competitive, and the bid activity was similar to that of Tranche 1, which was, as you might recall, quite competitive as well. To refresh your memory on our role, there are 6 general things I break down our role into, and it's a review of 3 things. One is the communication with bidders. The second is the website access that bidders have, which is the repository of information that they use to make responsive bids. And then finally, the review of their eligibility to bid. We then do a confirmation of the NRNOC fees that are charged for use of their auction platform. We develop a power market assessment, and we assist NRNOC in setting the opening prices for the auctions. And finally, we're present at the actual auction to confirm results and to monitor the process. For Tranche 2, there were only 3 blocks. Typically, in Tranche 2, there are 3 blocks of risky load and 1 of MGS, but in this case, there were just 2 as an adjustment to the total load that was available in the system. The block size is 52.3 megawatts for risky for both blocks and 48.4 megawatts for MGS. Participation in this year's Tranche 1 and 2 was very good, especially relative to that of last year. As you might recall, last year there was some uncertainty in the market due to PJM's proposal for capacity performance, which is a new way to hold a market for capacity resources. And due to that uncertainty, several bidders decided that they were not going to participate in this auction and other jurisdictional auctions as well. So if you look at the supplier count table below, it shows for every year since the 2009-10 period up till this year's 2015-16 Tranche 1 and 2, the EOIs, or expressions of interest, the number of companies that became eligible to bid, and then the number of actual bidders. The bottom line, literally, the actual bidders line is the most important, and you can see that for both tranches, we had 8 bidders total, which is consistent with what we've had going back 7 years. So the actual bid activity from those 8 bidders was very similar to that of Tranche 1 in that there were 7 bidders that showed up for the risky blocks and 6 for MGS. You know, most of the bidders do bid for both risky and MGS, but certain bidders only look at risky or MGS. And the number of bids between Tranche 1 and Tranche 2 were both, relatively similar, and it's a healthy amount of bidders and bids. We also look at the market, and we provide some insights to the Commission before the actual auction takes place. And the idea of that is to identify and analyze any potential risks or market conditions that could lead to a recommendation to postpone or even cancel any tranche. And we then establish opening prices, and we present a modeled target price range for each block as a rough estimate of what we could expect bidders to end up in terms of winning bids. As with Tranche 1, we did conclude that there were no adverse market conditions and that the auctions should proceed. So on the next page, to take a look at the energy market, if you could, I don't know if you could see this clearly, but there are 3 lines plotted on this curve. The red line is the price outlook in terms of forward prices for energy in the PJM Western Hub for the 3-year period commencing at this 2016 delivery period on June 1st. The black dashed line is the same graphic for Tranche 1, which took place in November, and the solid black line, which is the highest of the 3 lines, is the forward price projection from a year ago in Tranche 2. So we see that there's the same shape and magnitude among all of the three blocks that I'm plotting here. But we also see that Tranche 1 and Tranche 2 of this year are almost identical. It's rare to see prices stay that identical over the course of 2 months. So that was interesting. But we also note that the Tranche 1 and Tranche 2 prices shown here are substantially lower than those of Tranche 2 last year, and that's favorable. But really, when you look at electricity, you're looking at a cart that is leading a horse, and the horse itself is on the next page, and that is the gas market, because PJM's gas prices are really dictated by the electricity prices of PJM are dictated by the price of gas. And you'll see that, like the electric Fords, the Tranche 1 and Tranche 2 prices are almost identical, and that both are substantially lower than the prices of Tranche 2. And these low gas prices are the reason for the low electricity prices that are being experienced in PJM, and in fact in most other markets in North America. We spent a little time looking at other less important impacts or factors of the market. The first being the price of coal. The price of coal has some impact on overall energy prices in that it contributes to off-peak energy pricing. It's worth noting that, again, the prices between Tranche 1 and 2 are similar. They did drop a little bit over the last 2 months, but both are, again, substantially lower than what they were a year ago. Oil prices are substantially lower than last year, but Tranche 2 is actually even substantially lower than Tranche 1. As you all know, energy prices for oil just continue to drop. Oil prices don't really make that much of an impact on PJM's energy prices, but there is some impact. In conclusion, the market conditions were very similar to those of Tranche 1, and that we decided Tranche 2 should proceed. The auctions were well run, and they accomplished what was set out in the RFP requirements. And ultimately, the winning bids were consistent with the outlook for the general regional energy and capacity markets. So with that, I'll be glad to field any questions on the public portion of my presentation.
Thank you very much.
Welcome.
Any questions here, or do you want to wait and go into executive session? Okay. In order to go into executive session, we need to do that to discuss documents that are not public records, and the reason they are not public is that they contain trade secrets and commercial or financial information of a privileged or confidential nature related to standard offer supply procurement of wholesale electric supply, and we'll need a motion to that effect.
A motion to convene the executive session.
Second.
Okay, all those in favor?
Aye.
Any opposed? Any abstentions? Motion carries. We'll be in executive session for a few minutes, ladies and gentlemen. Thank you.